Welcome to our webinar on succession planning strategies for small business owners. My name is Sam Ferguson. I'm an attorney with the Goosmann Law Firm. Primarily, I do estate planning and business succession planning. I'm joined today by Sarah Laughlin. She is a transactional attorney with the firm and does business formations, business planning, and entrepreneurial law generally. She will be participating in this later on, and she will be giving the portion of the presentation on buy-sell agreements. Of note, if you're interested in the material that we're presenting on, we offer a free business succession planning consultation as well as a free buy-sell agreement consultation if you have a business partner. There will be a link for that at the end of the presentation, and so if you're interested, go to that link, put in your contact information, and we will reach out to you to set up that complimentary consultation at your convenience. We do travel. I travel through all parts of the state of South Dakota and into North Dakota as well, and so if that's something that you're interested in, we can travel a reasonable distance to meet your needs. Jumping right in, a note on why this is important. Generally, people don't plan for the successful transition of their business, whether that's down to the next generation, down to a key employee, or to a third party that they don't yet know the identity of. Generally, people just have in their mind some idea that, oh, I'd like my business to go down to my kids equally, or, oh, one of my employees will buy me out, or, oh, one of my competitors will jump in and save the day. And the reality is when you fail to plan, you plan to fail. Or excuse me, when you fail to plan, you plan to fail. So looking at these numbers right here, you can see that if you are not planning and making specific steps for the transition of your business, then you're planning to fail. Your business will not successfully transition. And what am I talking about when I say successful transition? Generally, if you do not get into specific planning to pass your business down as a going concern, or what that means is as an ongoing business interest, then you're going to have to sell your business for parts. And that will prevent you from capturing a lot of value out of the business. And so what we're going to talk about today applies to most small business owners. And I'm going to start with an example of an existing client who allowed me to share their story. I'm not going to share their specific identity, but allow me to introduce Bob and Bob's Oil. Bob is a small business owner in a rural town in South Dakota, and Bob has had this business for 30 years. It's a petroleum business. He goes and fills people's tanks, and in this rural part of South Dakota, they don't have city gas lines, and so he fills tanks for propane and natural gas for individual homeowners so that they can heat their homes and cook their food. And so Bob has spent all of his time and money and resources building up his business, but in that process, he hasn't really captured a lot of the value out of that business. Specifically, he has not saved for retirement, and all of his money is in the equipment of the business, in the business's inventory, paying his employees. And a big part of this is Bob is absolutely essential to the success of the business. The business could not effectively survive without him. He runs it. No one else knows all of his systems and processes. He has longtime employees who know parts of the business, but in reality, Bob's the only one who understands how all of it works together. Now, if this is sounding familiar, sounding like sort of how your business is, you've invested your time and money and resources into it, but haven't captured much monetary value out of it in terms of saving for retirement. And if you are absolutely essential to the success of your business, then you are in the right place. There's no more important place that you could be right now than listening to this webinar. And that's what we want to do, is we want to help you capture the most value out of your business, because when you sell it as an ongoing business, you're going to capture a lot more value out of that legacy that you've built up over the last several years than you would be able to if you were selling it for parts, just selling off the inventory, selling its individual assets. So it's rare for rural business owners like Bob to pull a lot of money out of the business for their personal retirement. And what this does is it results in a big asset at the end of one's career that's worth a considerable amount of money. But the problem is, how do we capture the value out of that asset? We may pass it to a loved one for no money. So if we're looking at gifting it down to the next generation, to the spouse, grandchildren, whatever it may be, but that's really only a viable option if we've saved separately for retirement. More likely, you're going to have to liquidate it, and that's not optimal. Looking at the fate of Bob's Oil, so what happened here, really what happened is Bob passed away at the end of last year, and it was unexpected. He had not identified a successor for his business, so he had key employees that understood a lot of it, but they didn't know everything that Bob did. Bob did have a will, and that will left everything to his wife. Now, Bob's wife has never been involved in the business. She's a teacher. She's never been in the oil operation. And now suddenly she's 100% owner of this business that she doesn't understand. She's lost the income that her husband's been bringing in. She doesn't have money to cover Bob's funeral expenses because all that money is tied up in the business. And now she's the decision maker over the business and its employees who are relying on her to help them keep their jobs by keeping the business running. So Bob's wife is confused. It's a time she should be able to grieve, but instead she's got to run this business that she's never understood or been involved in. So she contacted us less than a month after Bob passed away because of this mounting pressure to run this business. And she didn't have time to run it because she's still a teacher. It was the middle of the school year. So all this while she should have been able to have time to grieve the loss of her husband. Even if Bob had not died unexpectedly, he still wasn't prepared to pass on this business and retire. He didn't have a succession plan, and he would have had to have continued operating the business until he couldn't anymore, at which time he would have had to liquidate the business because he never identified who his successor would be or put a plan in place for how to transition the business down to that successor. Now, ultimately, we had some luck work in our favor, and we were able to help Bob's wife sell the company to a competitor looking to expand operations into that area. That competitor had a unique need for some of the assets that Bob's Oil had that the local competitors did not need at all. And so it was very fortunate. It was excellent timing, and we were able to capture a lot of the value out of the business for Bob's wife. But that is not a common windfall that we got there. So we got lucky. If that competitor hadn't been looking to grow as aggressively as it had, there would not have been a viable buyer in this situation. So for a lot of rural small business owners like Bob and Bob's Oil, all the owner's time, resources, and cash are tied up in the business, and most don't have a set of potential buyers waiting for the owner to sell the business. Most don't even have a successor picked out, like a key employee or a child that's ready to run the operation, because in rural towns, South Dakota, we're looking to get out. A lot of those kids want to move away from home and aren't interested in necessarily coming back. So instead, most rural small business owners have made the business operation totally dependent on the owner's well-being and continued involvement. And this is a recipe for disaster because there's not always going to be a growing competitor looking to snatch up the business. And so I was looking for an image that had a headstone for Rest in Peace Bob, and I found this cartoon someone had put on there, and it said he died doing a silly dance. And that's exactly what this is. If you haven't picked out a successor, if you're not sure how this business is going to be transitioned down the road so that you can capture value out of it, you're doing a silly dance, and we want to avoid that. All right, so jumping into the meat of the presentation, we want to look at business succession options. So the first option is to gift the business to a family during life or at death. And the second option, sell the business to a third party. Third, sell the business to key employees or successors. And so really there's an option that I haven't mentioned in this slide, and that's what happens when you have a business partner. We're going to talk about that as part of the first option, actually, because a buy-sell agreement, which Sarah is going to cover, is the single most important document you can have in place between business partners. And what it does is it says if one of us passes away or we hit some other triggering event, we're going to make an automatic business transition to the partner. So we're going to get into that as part of this first one. But before that, let's talk about gifting the business to a family or whoever during life or at death. Generally, when you want to give something at death, a lot of people use a will as the document that carries out those wishes. A will is the most common form of gifting at death. It's the most common estate planning tool that Americans use. In my experience, and I do estate planning day in and day out, will-based plans are not an effective way of passing your business at death. And the big reason why that is a process called probate. It's a public judicial process where a court oversees the administration of your estate, and it's going to cause some problems. Namely, probate, one, is public. Everything that goes through the probate court becomes public record. So if you want to maintain privacy of who you're passing your business down to, or how valuable it is, or the terms by which you pass it down, then a will is not your best option because the public can access those records. B, when you go through probate, administration is lengthy. Generally, we're looking at between 12 months and 18 months to administer someone's probate estate. And so it takes a long time. And C, it's very expensive. When you go through probate, you hire an attorney who files motions to the judge approves or denies those motions, and there's a lot of back and forth. There's a lot of legal documents that have to be filed. And in South Dakota, courts have found that it is reasonable to charge 2 to 3% of the value of the gross estate. So even if you have $1 million asset, and it's mortgaged or collateralized to the teeth, then the attorney is still going to be able to charge you 2 to 3% of the value of the asset regardless of the debt. So not the net value, but the gross value. So that gets very expensive. If you have $1 million, that's 20 grand straight into the attorney's pocket, 20 to 30 grand. So my experience, it is better to use a living trust. And what's this living trust that I'm talking about? I'm talking about a revocable living trust. What this is, it's kind of like a funnel. You change ownership of certain assets to your trust, or you name your trust as the beneficiary of certain assets, like life insurance policies and retirement assets. And what this trust does, like I said, it's like a funnel. It says, here's what to do with everything once I pass away. And because you've designated that in this changeable document, you avoid the probate process completely. Now, when I say you avoid probate, here's the benefits of that. First off, we keep things private. We said probate is public. Revocable trusts are generally private, and in South Dakota especially, it's perpetually private. So that document and the beneficiary's identities, even if it's litigated down the road, will never become public information. Those documents are sealed perpetually. Second, it's much faster to administer a trust than it is a probate estate, so a will. Trust administration takes between 2 to 5 months, whereas the will, as we mentioned, takes between 12 and 18. So it's a lot faster. And finally, trust administration is much cheaper when you pass away than it is to administer a will through probate. Whereas probate, you pay an attorney 2 to 3% of the value of the gross estate. We typically administer trusts for between $500 and $7,500. So if you have $1 million estate, that's a lot better than paying 20 grand right out of the gate. So the downside of trust is they cost a little more on the front end, but an important part of this is remembering that they're revocable. You can change them at any time, just like you can a will. And it's actually fewer formalities to change these and update them as your circumstances change. Another benefit of trust rather than a will is how you give things down to the next generation. So you can take into account special needs planning if you have someone that needs to qualify for government benefits. And most importantly, you can protect that inheritance that you give down from your beneficiary's creditors. So if they've gotten sued and lost, or if they've gotten divorced and they have an ex-spouse that's trying to capture all their assets, we can protect against those creditors so that their inheritance does not go into the wrong hands. So in terms of gifting your business, a trust is a lot more sensible and valuable option than gifting through a will. When we give away a business or other assets at death, there are some tax issues to be aware of. Now, I'm going to talk about federal tax because state taxes vary among different states, and there's so many different ways that we don't want to get into that right now. On the federal level, what we're mainly looking at is a gift/estate/inheritance tax. What that means is whenever you give an asset away during life, or if it waits till death, there is once you hit a certain threshold, every dollar after that is taxed a gift or gift or estate tax on the federal level of 40%. Right now, an individual can give away during life or at death a total of $11.4 million before that estate is taxed on what you give away. Now, that number actually doubles for married couples that file jointly. And a very important part of this is if your spouse passes away and gives everything to you, you can preserve that portability because there's no tax when you give anything to a spouse. So portability allows you to preserve your spouse's exemptions so that when you pass away, you can effectively give away up to $22.8 million. Now, gifts during life chip away at that exemption if the gift is more than $15,000 to any one individual per year. So you can give to your kids, grandkids, nieces, nephews, whoever it may be. You can give away up to $15,000 a year before having to file a gift tax return. But once you get above that number and you file a gift tax return, that starts chipping away at that $11.4 million per individual. And remember, every dollar above that $11.4 million exemption is taxed at 40%. So that's something we want to avoid. It's a great problem to have because that means you have a lot of money. And in reality, very few people pay this tax. Right now it's 1 out of every 1,000 deaths pays federal estate tax. Another tax issue at death is basis. So when I'm talking about basis, I'm generally talking about what did you pay for the asset when you first acquired it. Tax basis planning becomes an issue when you have highly appreciated assets. And there's an example on this slide. Dad purchased 100 shares of stock and his basis is $100, so he paid $1 per share. If the value of that goes up to $200 or $2 per share, then Dad has $100 of capital gain because he's owned that asset for over a year. So you can imagine the tax effects on highly appreciated assets. So maybe Dad paid $100, but now it's worth $1 million or whatever it may be. He got in on Microsoft very early on, or whatever other valuable company, Apple, you name it. And so now he's got a very small asset, a very small tax basis with a very large asset. If he sells that before he dies, he's going to have to pay a lot of income tax to the government. Now, the neat thing about tax basis is if you wait to give that asset away until you pass away, then the tax basis will step up to its current fair market value. So you pass away and that $1 million of shares that you paid $100 for steps up in basis to $1 million. That allows your children to sell that asset without having to pay any taxable gain to the government. or at least a significantly less amount of taxable gain. So holding off on selling assets or giving assets away until after you die can be a very important part of tax planning, because that's a very big benefit that we get, is that our children or our spouses or whoever can receive the assets that we have that have appreciated in value with a tax basis that's set at fair market value. So that's very valuable to tax planning. Gifts during life, there's another couple things that we can do here. Sometimes people find a lot of value in making your business successor a current owner of the company. So rather than saying, hey, I'm going to let you become the sole owner once I pass away, or we'll do the transition all at once, some people say, hey, if we want them to commit, we need to make them an owner now. So we either need to give them some shares or sell them a minority interest in shares right now. And certainly there can be some value to that. It aligns their interest with the success of the company. If you're going to do this, one great way to do this is through a gifting trust. What this does is it allows you to give an equity interest in the shares, but so you make the successor, whether that's a child or whoever, you make them the beneficiary of this trust, but it allows you to retain ownership and control, not ownership, it allows you to retain control and voting power over those shares. So that way, the new owner won't be making bad decisions and voting contrary to you and running the company into the ground, but they still have the beneficial interest of it, so their interests are still aligned. They want the company to succeed so that they can capture the value out of it. If you're going to do either a gifting trust or make a successor a part owner right away, it's very, very, very important to get a buy-sell agreement in place governing the transition of shares when one of those partners exits the company for whatever reason. So I'm going to switch this over to Sarah now so she can talk about buy-sell agreements, what they are, and their importance in a business relationship.
Thanks, Sam. As Sam mentioned, I'm Sarah Laughlin. I do business transactions with the firm. And now we're going to discuss buy-sell agreements. So the goals of the buy-sell agreement are to not get stuck with a partner you don't want and make sure that everyone gets their fair share at the end of the day, as well as avoiding litigation. As Sam mentioned, if you gift to a family member, you're trying to encourage them to devote time into the business, and having a buy-sell agreement just lets you kind of take that back if the situation isn't working out, so that you don't get stuck with that partner that you thought was going to work out and then it does not end up working out. So we're going to talk more about how these work. All right, so they require an agreement at a point in time, right? So if you're gifting to a family member, you and this family member have to agree on the buy-sell agreement and how it's going to work, what conditions will trigger the buy-sell agreement, and we'll talk about some common triggers, as well as relating to transactions that may or may not occur at a future point in time, and also determining the price when that triggering event happens to determine what the buyout price will be. All right, so these are some common triggering events that cause either the other owners or the business to buy the departing shareholder's equity interest. So extremely common ones are death and disability. Right? If the other shareholder dies, you don't necessarily want to be in business with their estate. You might only want to be in business with the other shareholders. The same with disability. This generally refers to total and permanent disability, so that they're no longer able to help in the business. As well as retirement and termination of employment can be triggering events, and divorce and disagreement. So divorce along the similar lines, you may not want to work with their ex-spouse. All right. So what happens when a triggering event occurs? Well, let's talk about other things to consider in your buy-sell agreement first. So besides, you'll want to consider the triggering events. You'll also want to consider things like don't compete agreements. So if someone leaves for retirement, or if they leave employment, are you going to allow them to compete and work in businesses that are competitors of yours? Or do you want them to go to a totally different type of business or maybe a different region of the country to continue in that kind of business? Similarly, you might want to consider disclosure, whether you want any type of confidentiality in place for these buy-sell agreements. I'm not going to go over all of the 16 Ds to consider. These are just things to discuss with your attorney when you're working through a buy-sell agreement. All right, so these are generally the types of buy-sell agreements, and they're categorized by how the price is determined. So there's three main types, which is fixed price, formula, and process agreement, and now we're going to go through each of these individually. So fixed price is exactly what it sounds like. You and the other owners come together to agree on a price to buy the other out. Usually this is out of date and doesn't reflect the value of the business. Generally, we try to have the business owners determine the value every year or 2 years. However, that's dependent on the business owners remembering every year or two to come together and also have to agree on what the value of the business is every year or 2 years or however often you decide. As well, if the price is too low, then you're essentially hoping that the other person dies first so that you can buy the remainder of the company at a low price. And if the price is high, then you're betting that you die first so that your estate gets the highest amount of money. So advantages are it's easy to understand and negotiate. You're just negotiating a flat dollar amount. It's inexpensive then to form because of this ease to understand and negotiate. However, as we mentioned, one of the disadvantages is that it's not updated very often. So the price is usually out of date. It's difficult to reevaluate at a later date as you and however many other shareholders are in the buy-sell agreement will have to agree on the price. And then it can result in those inequities on buyout where either the price is too high or the price is too low. So one party isn't getting their fair share essentially. So a second option is a formula agreement. So instead of coming together and saying, okay, it's $500 a share, you come together and say, all right, let's come up with a formula. So a common one is based off of a multiple of earnings or values. So 2 to 3 times your EBITDA could be a common formula to determine the price. Again, it provides a reliable method of calculating the price. You determine the EBITDA, you use the multiplier, and that's the purchase price. However, usually you don't calculate this purchase price every year, so you might not know exactly how much to expect when the buy-sell agreement is triggered, and it might not be the best method to calculate the value of the business anymore. Your business or industry might undergo changes, which maybe makes EBITDA not a great way to estimate your value any longer. And then again, we come into the problems of now you have to agree on a new formula, etc. So a third option is a process agreement. So you're agreeing generally to have a appraiser set the price for the business when the buy-sell is triggered. So you generally write out in the agreement, how an appraiser will be determined. Sometimes you can hire multiple appraisers to make sure that they're in kind of the same price range. And then some advantages is it's, again, very reliable. You're hiring professional appraisers, and it probably gives the most accurate idea of what the actual price and value is at the triggering event. Similar to the formula disadvantage, you might not know ahead of time what the price will be. So if your triggering event is retirement, you might not know exactly how much to expect to get from your shares in order to plan for retirement. So those are generally the 3 main types of how you determine the price in your buy-sell agreement. All right, so how do you fund the buy-sell? When this actually goes through and the other party buys your shares, how are you actually getting paid from it, and who's getting exactly the shares? So generally, it's either a cross-purchase or an entity purchase, and then you can also do a combination of the two. So a cross-purchase would be where those other owners are purchasing the equity interest, versus the entity purchase is where the company redeems the departing owner's equity interest. Sorry about that. Oh, and then kind of the funding options combine with the type of either cross-purchase, entity purchase, or hybrid, especially if you're using life insurance or disability insurance, and then we're going to talk about that in a little bit. So generally, there's 4 main funding options that people use for their buy-sell agreement. So first, you could do a promissory note where either the company or the other shareholders are promising to pay over time that set purchase price. So you need to negotiate the terms on the promissory note. How long are they going to have to pay it? What interest rate are you going to do? It's easier on the buying shareholder because they don't need to have that money up front, right? They can pay that money with the profits of the business over that life of the promissory note. This also makes it riskier for the departing shareholder because the other owners might default on the note at a future time and become unable to pay. So a second option would be life insurance. So you're insuring the departing owner's life, and then when the departing owner passes on, then it gives cash to either the company or the other shareholders to buy their interest, and we'll talk more about that in a few minutes. So it's easy for both parties because it ensures that cash is going to be available. However, this really only works when the triggering event is death, because life insurance only pays out upon death. So you can also have disability insurance. This is very similar to what I just spoke about for life insurance, but the triggering event would be that total and permanent disability. And generally, your buy-sell agreement will dictate when the disability is triggered by the terms of your disability insurance to make sure that those are congruent and that the buy-sell isn't saying that you're disabled when the disability insurance won't pay out because they don't believe that you're disabled. So you want to make sure that those two are working together. So that there will be the cash available if the person becomes permanently and totally disabled. And then last, obviously, you can always pay with cash. It's accommodating for any triggering event. Unfortunately, a lot of times the buying owner doesn't have access to sufficient amounts of cash to pay upon the triggering event. Especially this makes sense if it's termination of employment, and termination of employment is not always, the selling party's choice. All right, so we're going to talk about how the cross purchase, or where the other shareholders are buying the departing owner's interest, works with the life insurance. So with the cross purchase buy-sell agreement, the owners are paying the life insurance premiums, and then the life insurance policy is on each business partner. So when a particular owner passes away, then the life insurance proceeds are paid to the surviving owners, and then the shares are passed to the departing or deceased shareholder's estate or family. And then the buy-sell dictates that now the estate must sell the shares to those surviving shareholders based on those other terms that we discussed. So the price and and then obviously the payment method would be those life insurance proceeds. So the estate and the surviving shareholders basically have an exchange of the life insurance proceeds and the shares that are in the estate. One really great thing that Sam had talked about with taxes is that the life insurance proceeds are not considered taxable income, and now the estate got that step-up basis for the shares. So there should be very little tax consequence to this, as the tax basis will be the fair market value, which should be similar to what you're selling the shares for. And now the remaining shareholders received that life insurance proceeds not as taxable income, so they're not taxed on that life insurance. So both parties should have very little tax consequences. So then the other option is to have that entity purchase with life insurance. So how this works is that the entity is actually purchasing the life insurance and paying those premiums. And then they have life insurance policies for every owner. So then when one owner passes, the life insurance proceeds are actually paid to the entity instead of those surviving shareholders. And then again, the shares pass down to the deceased owner's family or estate. And now there's an exchange between the entity and the deceased shareholder for those life insurance proceeds and the shares. There can be tax consequences to this if the entity distributes any of those life insurance proceeds to the remaining shareholders, because at that time it would be considered taxable income. And this can happen if there's greater life insurance potentially than the price of the shares. So the company is left with extra money from that life insurance that they decide to distribute to the remaining shareholders, which is when the taxable income would occur. All right, so we are going to take a quick break and stretch, and then Sam is going to go over a recap and move into those other two options for selling your business, either to a third party such as a competitor or to a key employee.
All right, welcome back. I hope you had a nice little stretch. We're just going to do a quick recap of everything we've covered so far. So first off, option one, we're giving your business away. Typically what we're talking about is we're giving it away at death. If we're doing that, we get a tax benefit. We get the tax basis of your business will step up to its current fair market value, meaning whoever you give it to can sell it without having taxable gain. That's great. If we are giving it away at death, we want to use a trust rather than a will. That way we can avoid probate. In other words, it's going to be cheaper to administer, it's going to be faster to administer, and we're going to keep the contents of your trust private, and we don't have those benefits when we pass through a will. And we can make sure that that inheritance for your beneficiaries is protected against their creditors. Now, that being said, realistically, giving away at death is unlikely to happen for small business owners, rural business owners, because you probably haven't saved up the retirement that you need. As we talked about, if all your time, money, and resources is invested in that business and you need to capture value out of it, you probably don't have enough value already captured to make it through retirement to get what you need out of it before giving it away at death. And so that's an unlikely option and probably not the best method of transferring your business. And another reason why that's not going to be the best option is because when you transition your business to the next generation, if you do it at death, then you're not going to be around to lend your expertise and help ensure the success of the business after that transition. So kind of like with Bob's Oil that we talked about, Bob's wife or Bob's children may have no idea how to run that business operation or no desire to run it. And at that point, they're forced to either look for a manager or a buyer. Or they'll sell the business for parts. That's what Bob's wife was going to do until we fortuitously found a buyer that was looking to expand into that area. That being said, they won't owe taxes on it because you got the step up in basis. If you must give business interests away during a life instead of at death, you got to make sure you're adequately protected, either retaining the voting power and control over it by giving it through a trust where you name yourself as the trustee, or making sure that when you introduce another owner into it, you're getting in that buy-sell agreement. And it's very, very important to make sure that you do that agreement right out of the gate. Do it while everyone's still getting along. We're still agreeing. We're still in the honeymoon phase of that business operation, because once you don't get along anymore, you're not going to get into a buy-sell agreement. And that buy-sell is going to govern your exit strategy. What it means when you enter into a buy-sell agreement, it means one of us is going to be the sole owner of this business down the road, whether that's because the relationship falls apart, or one of us makes some dumb mistakes and gets fired, one of us becomes disabled, one of us passes away. The survivor is going to be the sole owner of the business. And so what I'm going to talk about next in options 2 and 3 apply to once you are the sole owner of the business again. So the buy-sell is already played through, or someone's negotiated their way out of that partnership. You are now the sole owner of your business. So in short, we just talked about death and taxes, the two sure things in life, also the two most sure things to make you fall asleep. So if you need to stretch again, pause the webinar and keep going. All right. Okay, option 2 involves selling to an outside party. So we're looking at selling the business to a third party, usually a competitor that is not actively involved in the current running of the business. So this is a good option if you're not trying to create a legacy out of your business operation. There are some pros and cons. Pros here being most of the time you're going to get that entire sale price up front, which means low risk for you as the owner slash seller. You capture all the value of it right out of the gate. This is good because it's going to mean a clean break for you. You don't have to stay involved in the business. You don't have to be looking at it, be looking at the numbers to make sure that it stays a viable business. Cons here: we can't control what the buyer does with the employees. And so if making sure that your employees stay employed, that they keep their jobs, if that's a priority for you, that's something that's hard to guarantee in this type of business structure. So it can be negotiated for as part of the agreement, but it's going to be a hard one too. So another con: you can't control what the buyer does with the business, whether that's the business's continuation, the quality of the products or services that it offers, the business culture, or the community impacts. For a lot of business owners in these rural communities, having control over all of those things is very important. Having a good culture in the business, one that employees like to work in, being able to donate business proceeds or profits to certain charities or benefiting the community. You're going to have to cut ties with all that stuff, knowing that that competitor that purchased your business probably won't care about a lot of the same things that you care about. Another con to this type of arrangement is these are highly negotiated, which means there's going to be higher legal fees, and there's going to be a lot more back and forth on price and other things that may be important to you. So more than likely, this is going to be some kind of asset purchase agreement. What I'm talking about there is they're going to buy specific business assets rather than buying the whole business as an entity. That means that they're not going to buy all the business assets. You're going to be left with a few of them at the end of the day that you'll need to turn around and sell in order to capture value out of them. On the same front, they're not going to take over all of the business's liabilities either. So if the business owes money or has some contracts that aren't helping it out that it's going to have to pay out on, as the owner, you may be left with some of those after the sale of those assets. And so you may still have some work to do after this arrangement is completed. So it's not as clean a break as we thought. Furthermore, this is going to result in some income tax consequences. Likely, it's going to mean a high amount of capital gains. Fortunately, there is an annual exemption there. Hopefully you can structure it to stay below that, but that's something that you definitely need to include a CPA on in those negotiations. So things you need to consider when hoping to make this kind of transition to a third party: if you live in a rural town, it's way less likely that a competitor is looking to expand into that area or that some type of investor is looking there. And that's going to affect the purchase price. Formal business appraisers often discount the value of rural businesses due to lack of a potential buyer. So this may cut down the value that you are able to pull out of this business interest that you've put all your time and money into. So that's option two. It's simple, but maybe not the greatest in every way, because while it sounds great, you're getting paid everything up front, it's not quite as ideal as you may expect it to be. Option three, and this is what I think most business owners are interested, is transitioning the business to a key employee. There's a few ways of doing that, and the easiest method of selling a business down to a key employee is to have a purchase agreement by which you sell all of your shares in the company to that key employee. What this means is that you're going to sell the business as a whole, rather than just some of its assets and then you having work to do. You're saying, it's all you now. We're going to give you the whole thing. Pros to this: it's very easy to put together. So that means less legal fees and less negotiation. It transfers all of the assets and all of the liabilities, so there's no remaining assets that you're going to have to try and find a buyer for. There's no remaining liabilities that you have to wrap up before you can be done. There's no work left to do once all the shares are transferred. So you can either transfer all the shares at once, or you can do an installment sale and transfer shares as payments come in. It allows you to dictate the terms of the plan so that you can maintain the company's culture, you can maintain the legacy that you've planned, you can make sure the employees keep their jobs and stay employed. Now, that being said, some of these pros are tied to some of the cons. First off, in terms of maintaining all those things, is you're going to likely need to stay involved in the business to make sure that that's followed. And you're going to need that anyways, because most key employees don't have the money to pay for the business outright, or they don't even have sufficient collateral to get the bank to finance the purchase. So what that means is you're going to be paid out over time. You're not going to have one big lump sum where you're suddenly rich, capturing all the value out of your business. Nope, this is going to be an ongoing investment where you relinquish control, but they want to keep you around so that you can ensure the business stays successful. And you're interested in that because you want them to be able to make this payment. Sarah talked about installment sales and promissory notes. That's how this is going to work. They're going to pay you a % down, and then every month or quarter or every year, however you structure it, they're going to pay you an installment part of that purchase price. So to make sure that you protect yourself in that scenario, it needs to be a secured promissory note. What that means is that you take a security interest in the company's shares or in certain of the company's assets. When I talk about taking a security interest, what I'm saying is that you take an interest so that if they stop paying their obligation to you, you can come in and say, that's mine, whether that's equipment or inventory or even the shares. You can go back in and say, you know what, you guys messed up. You haven't paid me in 6 months. I'm taking ownership of the company. It's not ideal because the whole point of this was to get you out. But there is a remedy available to you so that you can come in and hire someone to run the company or try and sell it to a different party. So, but you know, the time yields the unforeseen. There's always risk in this type of structure where you're doing a promissory note and installment payments over time, because you can't see what's in the future. You can't guarantee the future success of the business and their ability to continue to pay you. Another con here is that the purchase price is limited to what that key employee feels comfortable paying over time, as well as what the business can handle paying. You don't want to strap that business with a payment that is going to cripple it and make it unavailable or unable to continue to make money. And that can be very, I mean, even if it can pay it, but it's not making any additional profits, that can be very unmotivating for the successor. So we want to make sure that the company can continue to make money and that this obligation isn't so large that we're discouraging the successor from being profitable. So anyways, some solutions to these issues. We talked about a security agreement. With that, you're going to file a financing statement. That tells the world, as in potential lenders to the company, that you're first. You get first priority in those shares or those assets, whatever it may be. Second solution there is you want to negotiate that you stay on as an employee of the business. You want to make sure that those successors, even though you don't have voting control over them, you want to make sure that you can provide your expertise. You've been working in this business for 10, 20, 30 years. You know the ins and outs, and you know how these clients work. And having you on is going to help maintain continuity for the clients, and it's going to help these young, inexperienced business owners to know how to handle things as they come. And they are more than likely, they're going to want you to stay on. They will want your expertise to make sure that they can be successful and that they can pay your interest out so that they can own the thing free and clear down the road. Your biggest risk here is that to make this type of plan work, where you're selling to a key employee over time, is it takes time. You can't just wait until retirement and then assume an employee will step up to the plate and take over. You have to start planning this 5 or 10 years in advance. It takes grooming. You want this employee to do what you do. If you're indispensable to the company, you need to make them indispensable to the company. So, you know, for after that transition. So, make them know everything that you do and help them to become capable of managing it the way that you manage it. So if you become dispensable, and so that you have to become dispensable, and then your successor can become indispensable. The biggest risk is here. What if you lose that employee? If they leave or die before the transition is complete or before you even sign that purchase agreement, then we have some issues. Or if they become permanently disabled after you've undertaken to groom them, but before you've completed the transfer. And the solutions here are, you want to keep them from leaving by incentivizing them to stay. So, unemployment right now is really low, and people get offers all the time, to be paid more doing the same thing or even less than what they're currently doing. How do you protect against that? It's a hard thing to do, but there's all kinds of insurance options you can do to put golden handcuffs into place. Make it to where if they want to leave, they're leaving money on the table. And so there's some good investment options there. You also want to protect if that potential successor passes away or becomes permanently disabled. I've had several clients who we've met to talk about their estate planning, and they said they are business owners, and they said, the plan was always to sell to my son, but he passed away last year, or whatever it may be. And then they're left with, oh crud, what do I do? I'm supposed to retire next year. I'm getting old. I don't have the energy to keep this thing going, but I don't have a successor picked out that I've groomed and prepared to run this business. In those cases, make sure that that key employee has a life insurance policy or a permanent disability policy so that the business gets paid if some tragedy happens. You can turn around and use that money to hire a manager, to better groom a different employee and put some golden handcuffs in place on them. Or if you have to sell it for parts, those life insurance proceeds could make up the difference between what you could sell it for as a going concern versus selling it for parts. So protect yourself and make sure that you keep your employees around, or protect against the tragedy if something unfortunate happens to that key employee that is your succession plan. You also want to make sure you're protected after you've completed that purchase agreement. So if your buyer, the person you've transitioned the business to, they have this obligation to you as well as the business. If they die after that, how do you make sure you get paid the value of what's owed to you? Well, you want to maintain a policy on the buyer's life as well. So you sell the business to a key employee. You make sure you get a policy in place ensuring that employee's life. So if they die, you still get your fair payout. So make sure you protect yourself in that way. All right, option 3 is a different way to structure a sale to a key employee. This is a redemption structure. So rather than selling the entire business directly to the employee, in this case, what we're going to do is we're going to transfer a minority interest to that key employee or that successor. And then instead of doing a full negotiation where you sell the entire business to the employee all in one fell swoop, because they're a minority owner, you actually can have the company redeem your shares. So for instance, in this example, we give or sell 5 shares to the key employee. Then we have the company redeem your remaining shares, your 95 shares. Those 95 shares become treasury stock of the company, and then the 5 shares that your key employee holds, that suddenly becomes 100% of the issued and outstanding shares of the company. So that means your key employees, the value of their shares just rose substantially. Benefits of doing it this way: as a majority shareholder, you essentially get to choose your own purchase price. So the minority shareholder will have rights protecting him against minority oppression, but they're unlikely to pursue that route. But that being said, it's easier to negotiate redemption price with the successor or key employee / business partner that you're getting along with. So you're not going to try and give them the shaft by way overcharging or overstating the value of your shares, because you want them to succeed, because they're going to be paying you that the value of your shares over time. So while you get to essentially choose the value of your shares, you need to choose wisely, because you want to maintain a good relationship with Your temporary business partner will ultimately be responsible for paying out your interest over time, because we're going to have those same issues with regards to financing that transaction down the road. Because the business is the one making the purchase, it's more likely than an individual to be able to obtain financing. So if you want to pursue that option where the company gets a loan to pay out your interest rather than extending that payment obligation over time, you can do that. That's going to depend on you and your business partner and how you want to structure that transaction. That being said, this could cause a higher tax liability than being paid out over time. If you're getting paid in one lump sum, you're going to have some capital gains that if you extended it over time, you might be able to avoid. The cons, again, if you're being paid over time, you got to make sure you protect yourself. One thing I want to talk about before we close is the transfer of control. Generally, this is a question I get from a lot of clients is, well, do we transfer it all at once? Do we transfer voting interests over time, or all of the interests? And so a couple notes on this just real quick. When we're talking about transferring shares typically have two interests tied to them. One is equity, which means the rights to profits and losses. The other is voting power. Typically, common stock shares have both interests tied to them. And if we're going to make a transfer to a key employee, we're going to transfer both. We want that employee to be interested in the equity because that aligns their interest. The success of the business is tied to the money that they're going to get paid out. But we also want to give them voting power. At some point, they are going to want to have control over the business rather than allowing you to be the one calling the shots. So we can either transfer the equity and voting power together, whether that's all at once or in installments where we transfer interest over time. But another unique option is to divide the equity interest from the voting power. So say we have 2 voting shares and 98 non-voting shares. What that allows you to do is after you divide it, you can transfer the equity interest to the key employee now, but retain the voting power until you're comfortable or until a designated time that you think that key employee can take the reins and is properly groomed, is ready to run the company on his or her own. And so what that does is, again, it keeps them motivated because they want the value of those shares to increase. They want to be able to capture that equity out of the work they put in. But if you're concerned that they're not ready, if they don't know enough about the industry or whatever it may be, you can retain that voting power until a designated time or until they've hit some measure so that you can know, hey, they know what they're doing. We can comfortably transition the control now. Another way to do it, and this isn't pictured on here, is to have an advisory board in place where the owner can turn to that board of experienced individuals and seek that board's advice. And that board can serve in a non-fiduciary role so that the owner holding control doesn't have to follow their advice, but it's in their best interest to do it. I want to do another quick note on buy-sell agreements. If you're transferring your interest to a successor over time, so you'll be partners in the interim, you need that agreement. You've got to have it. Because ultimately you don't want to be stuck in business with someone that you never intended to be in business with, and you don't want to be stuck in business with someone that has an interest adverse to yours. Anytime through death or disability or bankruptcy or divorce or whatever that triggering event may be, if you get stuck in business with someone that now holds an equity interest in your company but not a voting interest, their interest might become adverse to yours because they may not understand the importance of keeping that business afloat or continuing to have a community impact or keeping your employees employed, giving them jobs. What are they interested in? They're interested in getting paid. And as a business owner, you know the value of sometimes withholding distributions in order to make sure these other priorities are maintained. So can't understress the value of a buy-sell agreement. So thank you all for watching our webinar. If you do have questions, please feel free to reach out to me or Sarah directly. And if you are interested in a complimentary consultation, follow the link at the bottom of this slide and sign up, and that information will get to us. We will reach out to you to schedule that consultation. We appreciate you taking the time to listen and look forward to hearing from you. Have a great day.